Lord, my name is Andrew Bracknell. I haven't appeared before you before. I apologize for not introducing myself.
Wait a minute.
Andrew Bracknell. I appear with on behalf of Mr. Down. The judgment and orders of the Supreme Court of Appeal on the 13th of October dismissing Mr. Zuma's appeal in terms of Section 18.4 of the Superior Court Act brought into effect the implementation order and judgment. Sorry.
I don't know what's happening now. My learned friend is addressing submissions which he has just given to us now. We're not there yet. As the prosecutor was still addressing the court. The only issue I was raising at this stage is that whatever proceedings looks like we're going to, because of these submissions, we're going to be here for much longer than we thought, which is fine, because we've just been given submissions. The point is that while all that is happening, my Lord, this is it. The reason the election went back to change robes, is because we are now in the criminal court, and whatever happens, the accused should be when they are supposed to be. Whatever Mr. Pietermaritzburg's submissions are going to be, like in the normal way.
If I may, I'm outlining, I'm not dealing with the submissions that are handed to my effect. I'm outlining the following basic proposition, and it is that at the moment there is no private prosecution. The full court of this court ordered that the summons be set aside. It further ordered that that order be implemented pending the appellate processes which Mr. Zuma may follow in relation to its main order. The second order, I call that the implementation order, was taken on appeal to the Supreme Court of Appeal by Mr. Zuma, as was his right. That appeal was dismissed on the 13th of October 2023. It follows that the immediate implementation order is in effect and there is no private prosecution.
Allow him to finish. Because I'm also going to allow Mr. Mwaitobi to address this issue, that issue as well.
Just at that point. What my learned friend is doing is not correct now, because he's forcing this court to commit an irregularity, which we don't want to go there. But all we're saying at this stage, Mr. Pietermaritzburg, as he is within his rights, has given us a few minutes ago about 10 pages of submissions, which is now going through. We're going to address those submissions, obviously, and in fact, that's what I was going to say to you, that although you correctly allowed me to speak first, because of this Mr. Pietermaritzburg should address the court first so that we respond. But all I'm saying is that that does not detract from the fact that we're here in this court right now. And this is, whatever points he's raising them in the criminal prosecution itself. That's what we're here. It can be that once he has made his submissions, then we will determine whether we're here in a criminal court or not. So he must either address that issue specifically or but not go into all these submissions so that the court can make a ruling on that specific issue.
Thank you, Madam. That was what I was attempting to do very briefly. The point is simply this, that the full court of this court has ordered that the summons be set aside and that its order not be suspended pending the appellate process. So as we sit here today, to appeal against that having failed, there is no summons. It has been set aside. And it follows that today's proceedings are not the continuation of the private prosecution. The summons having been set aside by the full court. My Lord, I appreciate that there is an argument on the other side that Mr. Zuma's appeal that he lodged with the Constitutional Court, an application for leave to appeal on the 25th, changes all that. We submit on the binding authority of the SCA in the City of Tshwane case that appeal is irregular, invalid, and in any event Section 18.2 applies to it. So the short answer, my Lord, is this. There is no criminal matter on the roll today because the summons has been set aside by the full court in an operational order which is binding on the Lordship. And it follows from that Mr. Downer need not be seated in the dock as my learned friend has requested. Those are submissions.
Right, let me hear Mr. Muraito. Mr. Muraito, what's your argument with regards to whether Ms. Maughan should sit in the dock?
Yes, Ms. Maughan is also not sitting as an accused. The first question that your Lordship needs to ask is whether or not there is a valid private prosecution today. That's the first question. Because once you have answered that question against us, Ms. Maughan must sit as an accused. Once you have answered that question in our favor, she is correct where she is sitting. So it is impossible to jump the gun, as Mr. Mpofu proposes. We must first go through the hurdle of whether or not there is a valid private prosecution this morning. Now, we say to your Lordship, there is in fact in law no valid private prosecution. We have written 2 letters to Mr. Zuma's attorneys. My attorneys have written 2 letters in which they say they should consent to the removal of the matter from the roll. Twice Mr. Zuma's attorneys have refused, and they have insisted that we should appear here. But in law, we should not appear here. We have sought to get directions from your Lordship in order to avoid the spectacle of this morning. But we have failed to get those directions. And we are now having to do what we could have avoided in court. But then it remains the question of law. Is there a valid private prosecution this morning or not? Because it's really the answer to that question that will decide where my client should sit. Now, I want to address that frontally because we should not appear to avoid it. There are 4 rulings in this case against Mr. Zuma. 4. They all make it clear that there is no valid private prosecution. The last was given on the 4th of October 2023 by a unanimous Supreme Court of Appeal. Now I want to quote what they say specifically, my Lord, so that there is no ambiguity about what we are doing, because we would never undermine your Lordship's authority. But we would insist that your Lordship should follow what the higher court has said. Paragraph 23 of the judgment of Justice Ponan says the following, and it was addressing this very issue of the appearance of Ms. Maughan today, and it says the following: a suspension of the High Court's orders and the continuation of the private prosecution while Mr. Zuma is attempting to appeal will negate the orders issued and result in the respondents forfeiting the substantive relief which that court ordered in order to put a stop to the abuse. The premise of the argument advanced on behalf of Mr. Zuma is that the purpose of the implementation order was to prevent the next appearance of the respondents in the criminal court on 4 August 2023. Let's take that to be 1 November 2023. But that is to take too narrow a view of the matter, says the SCA. It was to prevent their continuing appearance in the criminal courts from time to time, to avoid the delays and obstruction in Mr. Zuma's criminal trial that will result from the continuation of the private prosecution, and to avoid the private prosecution being used in an attempt to remove Mr. Downer as the prosecutor. This harm continues beyond 4 August 2023 and will persist pending attempted appeals. Should this court not dismiss the current appeal and confirm the High Court's enforcement order, the respondents will once again have to appear as accused persons on 1 November 2023 and on further dates in the future, pending the progress up to the Constitutional Court of Mr. Zuma's applications for leave to appear against the main judgment. I want to say two things about this paragraph. Firstly, the Supreme Court of Appeal has made it abundantly clear that the continued appearance of Ms. Maughan in a purported and an unlawful private prosecution is itself an abuse. And it has made it clear that if it does not enforce the order of the full court, it would play into the hands of Mr. Zuma, who is abusing the courts and abusing the private prosecution. Then paragraph 24 goes further if paragraph 23 is unclear. It says the mere decision to prosecute can have a far-reaching impact on an accused person's life. It should not be lightly made, because even if an accused is ultimately acquitted, the harm already suffered could prove to be irreparable. And then they quote another judgment of the Supreme Court of Appeal. Then look at what they say after they have quoted the judgment of Western Areas. They say, on each occasion that the respondents, that Ms. Maughan, are compelled to appear in the criminal dock, in other words, where they are now being told to appear, their personal liberty is further inhibited and human dignity further eroded. So, we stress this point. If you direct Ms. Maughan, because this is your court, you have a discretion, to sit in the criminal dock, the Supreme Court of Appeal has told you that you are inhibiting her human dignity and eroding her personal liberty, because you are subjecting her to an abuse in the hands of Mr. Zuma. And then they continue, the indignity is compounded by the personal insults that they, in particular Ms. Maughan, have to endure, especially on social media. Mr. Zuma shrugs that the social media abuse of Ms. Maughan is an occupational hazard and comes with the territory. Nothing could be further from the truth. What Mr. Zuma fails to appreciate is that these violations constitute a steady erosion, not just of her liberty and dignity, but will also discourage other journalists from reporting on powerful individuals for fear of similar reprisals. Guaranteeing the freedom of the press and public confidence in judicial authority and administration of justice is an ongoing process and requires constant vigilance. So, the Supreme Court of Appeal could not have been clearer that you cannot allow Ms. Maughan to appear purportedly as a criminal accused. They used the word the dog. That's what we are dealing with today. So she has been explicitly excused by the Supreme Court of Appeal. Now what has happened to change this is that there is an application for leave to appeal to the Constitutional Court. This is what has been trotted out as a justification why the order of the SCA should be disregarded, because that's really what we are dealing with. Now, I have not, Your Lordship would not have considered the heads of argument of Mr. Breitenberg, but they are instructive at paragraph 12 in citing the judgment of the City of Tshwane. Oh yes, if I may hand this up, I'm told that Your Lordship has not been given a copy. Thank you very much. It's only one judgment I want to refer to Your Lordship, which is at paragraph 12 of the note that has been submitted by Mr. Breitenberg. It's the case of City of Tshwane Metropolitan Municipality versus Vrestena, Pty Ltd, which defines what the next highest court means as per section 18.4 of the Superior Courts Act. Now, Your Lordship will remember what that section is about. It's the section that explains where a court has granted a leave to execute pending an appeal, what should happen. It is section 18 subsection 4 and subsection Roman figure 2, which says the aggrieved party has an automatic right of appeal to the next highest court. So the issue in City of Tshwane versus Vrestena was whether there is a court beyond the Supreme Court of Appeal for the purposes of section 18. And the Supreme Court of Appeal made it absolutely clear that for the purposes of a section 18 appeal, there is no court beyond the Supreme Court of Appeal. In other words, Mr. Zuma has reached the end of the road on the enforcement issue. So the fact that he has a right under the Constitution in terms of section 167, he has no right of appeal. He has a right to apply for leave to appeal. There's no right of appeal. It's unlike section 18, which grants him the right of appeal, where he does not have to ask for leave. Where we are right now is that an application for leave, which resides with the Constitutional Court, has been submitted. What that cannot do, it cannot overturn the explicit language of section 18.4, nor can it overturn the explicit ruling of the Supreme Court of Appeal, which means the order that was granted by the full bench here on the 4th of August, if I'm not mistaken, on the 4th of August, it's dated the 4th of August. Now, the order that was given by the full court on the 4th of August in relation to Ms. Maughan, which says the operation and execution of paragraphs A1 and A2 of the orders of the full bench given under case number 1277022P shall not be suspended pending the final determination of any applications for leave to appeal. And what was that order that shall not be suspended? The order is clear. The summons issued out of the KwaZulu-Natal division for the purpose of instituting a private prosecution against the applicant is set aside. The respondent is interdicted and restrained from reinstituting, proceeding with, and from taking any further steps pursuant to the private prosecution. The cost of the application will be paid on an attorney and client scale. So we have the first order of the 7th of June, which makes it clear that there is no private prosecution. We have that order affirmed on the 4th of August by the full court saying it shall not be suspended. We have the Supreme Court of Appeal making it absolutely clear that any appearance in the dock would be in violation of those orders. And then against that, what do we have? Is an application for leave to appeal against authoritative statements by the judges. So it is time, Your Lordship, makes this clear that any attempt at getting Ms. Maughan to appear as an accused, or any attempt, I don't speak on behalf of Mr. Downer, he's got his own counsel, let me stick to Ms. Maughan. Firstly, would be inconsistent, let me not elevate it to the level of contempt, but it is certainly inconsistent with the ruling of the Supreme Court of Appeal. It is directly in breach of the order of the full court granted on the 7th of June. It is inconsistent with the order of the full bench given on the 4th of August. In fact, if Your Lordship ordered Ms. Maughan to appear as an accused, Your Lordship would be party to undermining the authority of the court. You would be undermining the full court, you would be undermining the Supreme Court of Appeal. And that is why Ms. Maughan is not required as a matter of law to appear in the dock as an accused. So we come back then to where we started, which is the only basis on which Ms. Maughan would appear as an accused is if she is in fact an accused. She is not an accused merely because Mr. Zuma says so, particularly when he says so in the face of rulings by the court. So Your Lordship is then requested in those circumstances to simply affirm the legal position, either by removing this matter from the roll, or striking it from the roll, or postponing it indefinitely, because as a matter of law, there is no criminal prosecution. And unless that issue is answered in favor of Mr. Zuma, Ms. Maughan is entitled to sit where she is. We've told her to come to court because we could never undermine Your Lordship's authority. But we've told her that as a matter of law, there is no private prosecution against her, and we will be making the submissions to your Lordship. So it is not because she is undermining anything. It is simply because the Supreme Court of Appeal has been the last word on the subject. And in those circumstances, there is no basis then to say she must appear as an accused. Otherwise, we would be aiding and abetting the contemptuous conduct of the private prosecutor. Thank you, my Lord.
Before you sit down, Mr. Toby, since you are addressing me, you initially started off by addressing me on the validity of the private prosecution. I want to refer you to paragraph number 25 of the judgment of the Supreme Court of Appeal.
25
paragraph
of the...
number 25.
Sorry, my Lord, I need to just...
judgment of the Supreme Court of Appeal in... That is Judge Bonham's judgment.
Yes, my Lord.
Paragraph number 25, right at the bottom, the finding by the Supreme Court of Appeal, right at the bottom where it was held, in the circumstances to permit the continuation of a private prosecution pending an appeal as to the lawfulness of the prosecution likely constitutes a direct violation of the constitutional rights of the respondent. Do you want to address me on that?
So, my Lord, you are looking at 25.
Paragraph number 25, right at the bottom, the last sentence. Page 13.
Oh, yes. Yes, I mean, the respondents in that case. Oh, yes, my Lord. So I have addressed Your Lordship on two aspects. Number one has been the history of the matter, and number two has been the authority of the court. But Your Lordship is bringing my attention to a third facet, which is the rights of the accused or the rights of the respondents. So what that paragraph is about is to simply say, if the private prosecution is allowed to persist, that would, in these circumstances, be a violation of the constitutional rights of the respondents. And that is largely because of the finding made in paragraph 24. Because in paragraph 24, Howie P., as he then was, already found that one cannot say, I want you to appear in court, I'll postpone the matter. Because the appearance in court is itself an infringement of the two rights, liberty of the person and the dignity of the person. So the fact that we are here today, purportedly, Ms. Maughan in an accused capacity, is inconsistent with the finding of the Supreme Court of Appeal, which says any continuation of Ms. Maughan appearing as an accused is a direct violation of her constitutional rights. And those constitutional rights are already spelled out at 24, which are, and it says here, a criminal trial cuts across a number of an accused person's fundamental rights. Attendance at the trial, even if on bail, limits the freedom of movement, and even the right to liberty is kept to an extent. And the Supreme Court of Appeal added dignity. So we in fact have three, not two. Freedom of movement, the right to liberty, and human dignity. And so that's what we would add, urged by your Lordship, is to say it's not only about the authority of the courts that we are trying to protect today. It is also about the rights of Ms. Maughan, that this instruction that she must appear in the dock as an accused is a violation of the Constitution. And that's not a finding we're asking your Lordship to make, it's a finding we're asking your Lordship to confirm, because it's already been made by the Supreme Court of Appeal. Thank you, my Lord.
I think I should go back. Should I just deal with Mr. Breitenbach, please, very briefly, on this issue, whether or not he should sit on the dock, in one line?
Sorry, I didn't hear you.
Whether or not Mr. Downer should sit in the dock, just in one line.
The answer to that is no. But like my learned friend Mr. Muketa for Ms. Maughan, your Lordship, he is present in court because he did not wish to disrespect the court. If your Lordship rules after hearing us that there is a criminal matter on the roll in which he's accused, then he will move to the dock, and we will then deal with whether it should be removed from the roll or postponed.
Yes. Your turn. Yes, Ms. Mpofu.
Thank you very much, my Lord. My Lord, Mr. Nkaitobi says that they do not want to undermine the authority of this court. And I suppose Mr. Breitenbach also says the same thing. But my Lord, I personally have never experienced anything like what I'm experiencing now, where the authority of the court is being undermined deliberately and for no apparent reason. Why are we, it's now 10:30, my Lord, and we're debating only the question whether the accused persons, whom your Lordship had warned to be here at 9:30 today, failing which a warrant for their arrest would be issued. And they're here, it's now an hour later, and they are doing a sit-in this court, or a demonstration, or a boycott of the law. They are arguing, my Lord, that they should not be placed in the dock. So we're now wasting the court's time, everybody's time, for the simple question of whether the two accused should sit there or sit here. The courts of this country must debate that. And while it is being debated, my Lord, they defy the order that was granted on the 4th of August. Their counsel justified their defiance before your Lordship makes the ruling. Now here's the rhetorical question, my Lord. Why, if they feel so strongly about not sitting in the dock, then why did they not go to the dock as ordered by the court? And then their counsel would then address your Lordship and say, my Lord, because of this and that case and whatever, we are of the view that the accused should sit in the public gallery, or they must sit here with the lawyers, or whatever. The Lordship will remember last week we were here. The first order of business, when I opened my mouth, my Lord, I said, my Lord, we request for permission for the accused, because at that stage, President Zuma was the accused, to not sit in the dock because this is an interlocutory application and so on. And the Lordship then duly granted us the permission. We could not have argued that interlocutory application for the whole day, my Lord. And then at 4 o'clock, when we were about to leave, then your Lordship then rules that, or we then ask for the permission. That would have been contempt of court, which is what is happening here today. And the reason we did that, my Lord, is because we could not preempt the court's decision. These people have now preempted the court's decision because they've already made a ruling, their own ruling, that they are not supposed to sit in the dock. So even if your Lordship can rule now that they must sit in the dock, they would have defied your Lordship for an hour or more. So that's, and we're told that they're here not to defy the court. That's exactly what they're here to do. In fact, I don't even know why they're here if they're not prepared. Because every minute that passes now, they are in defiance of the court order that was given on the 4th of August by your Lordship. And they have, in football, we call it, I don't know, in rugby at least I know what it's called. We call it ubuzerefa. In other words, you blow your own whistle and you decide that this is a foul, and then you take the ball. And when you are now penalized for a handball, you complain. But nobody said it was a foul except yourself. Now, so that's the first issue, my Lord, which second issue is what I was saying. They are almost forcing this court to commit an irregularity. Because if it turns out, whether now or in another court or whatever, that we are now moving into the second hour, that in these 2 hours they should have been in the dock, then that irregularity will have been committed and irreversible. And the Lordship will be blamed for something that's not really of his own making, which is just the voluntary defiance of persons who think that they are beneath the indignity of sitting in the dock like thousands and thousands of other people this morning across the whole country who are sitting in the dock, rightly or wrongly. Only yesterday there was a case where the charges were withdrawn against a particular accused, and as it happens every day. But that person, even if they think that they got the wrong person or whatever it is, they go to, in respect of the law, to the dock, and then they say, I'm the wrong person. Give another quick example, my Lord. Let's assume there's an accused in a car braking or whatever. That person gets arrested because he's wearing a yellow jersey. And they come here, then they are arraigned, and they are in court. The court court says, no, we're going to postpone the matter for the following day. In between, it's found that no, this was mistaken identity. The real person with the yellow jersey who broke into the car is Mr. Hua. The original person comes to court the following day, my lord, goes to the dock. The lawyers say, my lord, the right person has been found, and so on, and then the person is released. They don't come and say, oh, well, the right person has been found, I'm going home now. The court will see to finish. It's not done. It's the biggest form of defiance and disregard for the rules and the law of the land. Just for pure arrogance. There's no specific benefit that they get whether they sit here or sit there. They're already here in court as we speak. But they can't be subjected to what Mr. Zuma and other accused persons are subjected to, unless permitted by the court otherwise. So Mr. Breitenbach poses the question as follows, my lord. The court and Mr. Nivatu, the court has to answer whether there is indeed today a prosecution taking place in this court. Now, I'm sure people at home are wondering what that means. Whether we have to determine whether we're here, whether there is a court case taking place as ordered by this court on the 4th of August. I've never heard anything. Well, just to indulge them, we are here. There is a judge of the High Court, the accused are here, prosecution is here, their counsel are here, in case they haven't noticed. And we're here, the reason why Your Lordship this morning was hearing an application for leave to appeal. And we had to adjourn so that Your Lordship can go and change into red robes. Because, in case no one has noticed, we're now sitting in the criminal court. Now, so what they could have done, my lord, is, and we've said this to them, we've given them free advice. There's a matter related to this matter, my lord, in Gauteng. Your Lordship would be aware of it. Private prosecution by Mr. Zuma, and the accused is Mr. Ramaphosa. Mr. Ramaphosa, you can criticize him for anything, but he did the right thing. What he did was to say, okay, I am I'm arraigned to appear on the 19th of January. And I have qualms with the prosecution. But I know that if I don't do anything, I have to come on the 19th of January and sit in the dock and then make my objections if I want to. So what did he do? He was properly advised. He says, no, I don't want even to be in the dock in order to give all these explanations. So what I will do is to bring an interim application for an interdict to say that I should not appear on that day. Because otherwise, if I just don't rock up, I'll be arrested. He knew that. These people don't know. And therefore, he brought an application, my lord, was granted the right not to appear, so to speak. The private prosecution itself is still continuing, by the way. The next date, I think, is the 4th of December. So in that case, because there's an interim order, the court sits, we go like we do now, and every time we explain to the judge, sorry, my lord, don't be surprised that the dock is empty. It's because there's an interim order which excuses the accused person. Not to just come and defy the court in broad daylight and say, no, we're not going to sit there. You can do what you want, but we are sitting here in front. That's not done. That's so all they should have done is very simple, and we have suggested this in the exchange. You'll remember, my lord, in one of the letters, we even suggested that they should do what Mr. Ramaphosa did. So that's the one thing. And the reason, just to touch on the issue, my lord, the reason why that case is continuing, irrespective of that interim order, is because the court recognizes that in terms of Section 11, if the private prosecutor does not appear on the nominated date, then the matter will be dismissed. So what really happens there, there's a standard order which just changes dates. It simply says, number one, the matter is postponed to such and such a date, in this case for the 4th of December. Number two, the private prosecutor on that date will give the court an update of what's happening in the appeals and Part B and whatever. And that's what we always do. Mr. Ramaphosa, even though he's excused, always sends a watching brief in that court just to make sure that that happens smoothly. That's how it's done, my lord. Not this defiance, clear defiance of the previous court. Now let's come to, let me start just with one point that shows the ridiculousness of what is being said. Mr. Ngogatobi says that one of the things, your lordship, according to you, can remove the matter, strike the matter off, or postpone it.
Sine die.
Sine die, yes. Now,
with the rider, I suppose you suggested that if it is postponed sine die, it must be postponed with the rider that Mr. Zuma reserves his right to bring private prosecution afresh.
In other words, exempting him from the Section 11 impact. No.
Depending on the outcome of the appeal.
Of the appeals, yes. That is what, when your lordship raised the matter informally last week, that was one of the things. But we'll come to that, my lord. Mr. Pietermaritzburg is still going to make his submission. But I'm just raising this now for the purposes of showing how ridiculous the submissions are. So let's assume that your lordship goes for that option. Mr. Ngatobi says you will then postpone the private prosecution sine die. I might say, in fact, I'm going to suggest that if it's postponed to a specific date, but we'll come to that. Forget, it doesn't matter for now whether it's sine die or to a specific date, but the emphasis on the word postponed. So what is it that is going to be postponed? If Mr. Ngubatobi says there's no prosecution now, there's no case now, we're going to postpone what they had. Because by him...
Well, actually he said valid private prosecution.
Yes.
He qualified.
Yes, okay. So we're going to postpone an invalid prosecution or a non-existent one. What is that? Because that thing that he's saying must be postponed surely is this prosecution, which is valid. Your lordship, just make that submission just to show that all that is happening here is obfuscation and defiance of the court, deliberate. When your lordship pointed to paragraph 25,
yes.
Mr. Ngubatobi says, yes, thank you for pointing me to that, because it emphasizes the rights of the accused. Which accused? Because they're not accused, they're in the box. Which accused is Mr. Ngubatobi is talking about when he says that paragraph talks about the rights of the accused. According to them, there's nothing. I don't know, the private prosecution disappeared into the thin air. I don't know on which specific date, but as far as I'm concerned, it just disappeared. But the law doesn't work like that. If the private prosecution disappeared, we must be told at what precise moment did it disappear, on the basis of which sections of the law, on the basis of what law. Things don't just happen somewhere the private prosecution was here, but it's not here now. No, we must be told, I want to know the date on which it disappeared and the legal act that made it to disappear. Otherwise, it's still here. Now, before we go to the Criminal Procedure Act, let me, my Lord, disabuse my learned friends of this idea that they can rely on the judgment of the SCA. Because I think that's where the real problem is. It's a clear misunderstanding of the law. My Lord, let me start by saying the following. It is clear that the SCA made an order which would have made today's appearance a formality. And I'm using those words advisedly, my Lord. Even if nothing had happened, even if we had not applied for leave to appeal, we would still have had to be here. The accused would still have had to be in the dock. The lawyers would still be where they are. We would still be here. And we would stand up. Probably I would stand up, my Lord. And I would say, my Lord, this is what has happened. We've now had a judgment of the SCA. Therefore, although your Lordship ordered us to be here today, this is what has happened, and so on and so on. And I would explain to your Lordship. Your Lordship would then either say, I'm removing this matter from the roll on the basis of the SCA judgment, or do whatever your Lordship. It's in your Lordship's hands. And that's the point, the principle, my Lord. You are protecting, it might look trivial, but I can assure your Lordship, we're here to protect the integrity of our courts and the integrity of your Lordship from this abuse that is happening here. Because nobody, and we've said this in the letters, they wrote to the Judge President, Mr. Mvaitogo or Mr. Breton, I think it's Mr. Mvaitogo, says that they wrote, we refused that the matter should not be heard today. That's a lie, my Lord. What happened is that they did not write to us. Both parties wrote to the Judge President. That's the first stage of arrogance. If it wasn't for your Lordship's kind intervention last week, they just, we don't exist as far as they're concerned. So instead of doing the right thing, well, they would write to us and say, colleagues, there is this judgment. Shouldn't we jointly approach the Judge President and Justice Trilly and just for practical reasons, so that we don't all have to come to Maritzburg and so on. No. They ignore us. They write to the Judge President. Until we explain to them that no Judge President, Chief Justice, anybody can defy the order that was given by Judge Trilly. He said at 9:30 on the 1st, you must be there. There's no one, not even 1,000 judges, that can change that. It's a court order. It's not a court order of your Lordship's personal property. It's an order of the court of this country. So what they should have done, if they were not so arrogant, is to approach us. And then we'll say yes or no. Of course, we could have said yes, or we say no. If we say no, then they write to the Judge President or anyone, or come to this court and say what Mr. Nvaito is saying now incorrectly. We've written to these people, they've defied. It's not true. So that's another second defiance, my Lord. Going over the heads of the prosecution. Imagine if we did that, if we did that. What we would be called all sorts of things. Zuma thinks he's above the law and all sorts of things. If we said last week, no, Mr. Zuma is not going to come here, and we don't approach the prosecution, we just write to the Judge President or the Chief Justice and say he's not coming. Anyone who knows just about collegiality, forget anything else, would have known that it would have been our duty to approach the other side first. But no, these are special human beings. They don't do those things. They write straight to the judge and to the presiding judge, ceasing him or her. Now, so Mr. Ngogatop said,
I suppose I should just place on record, Mr.
Yes,
Mr. Mpofu, that I was not alive to the fact that you were not informed.
We were not. Yes. No, I'm sure your Lordship, I would never, your Lordship would never dream of thinking that the first letter actually was the one to the I can understand that now. And let me make it clear, we were copied to that letter, but the letter was addressed to the Judge President, not to us. Anyway, which takes us to June. Now, it is so that in June, my lord, they, I don't know which one, whether, I think it's both. In June, they had written to us. And there in June, they said, this was now after the 7th of June judgment of the full court. We don't think there'll be any need. Remember, the next date that your Lordship had put was the 4th of August. We don't think there'll be any need, and so on. And we said, no, we'll in fact, it was exactly a mirror image of what is happening now. We said to them, no, in fact, they said, are you going to do a leave to appeal? We said, yes. Then they say, well, we should not appear. We said, no, the judgment is suspended. And they came on the 4th. Let me just address that point, my lord. Why did the accused come here on the 4th of August and stand in the dock? Because that situation of the 4th of August is exactly the situation we have today. Except that on the 4th of August, they obeyed the law, and today they are defying it. That's the only difference. Let me repeat that, my lord. The legal situation that obtained on the 4th of August is exactly the legal situation that we have today. So if they were to defy, if there was any logic in their defiance of the law today, then they should have done it on the 4th. Why did they not do it, my lord? They didn't do it because they obeyed your lordship's order, which had said in April, come on the 4th and we will deal with the matter here. And we did exactly what I've described, my lord. We gave your lordship an update of all sorts of things that have happened, and then your lordship made the following date. You will remember Mr. Badlander Jr. made a feeble attempt to say, well, my lord, we will see whether we appear on the 4th or not. We'll cross that bridge when we come to it. I stood up here, my lord, and I said, what bridge is he talking about? Your lordship has just made an order that these people must be here on the 4th. There's no bridge, and the lordship indeed agreed with me and gave the normal order. Be here on the 4th at 9:30, failing which you'll be arrested. So there is no legal difference. And let me explain what I mean by that. What was happening in August is exactly what's happening now. There is an application for leave to appeal to a higher court, just as there was on the 4th of August. The only difference, my lord, is that that appeal has now been decided by opponent JA and the others. And my lord, it is a waste of your time, with the greatest respect, to then go into that judgment. Because they should have done the same thing on the 4th. They should have just said, well, there's a judgment of Kruger J and others, and read how bad Mr. Zuma is, and Stalingrad, what, and then say, therefore, we can't appear. Because that's what they're doing now. You cannot rely on the very judgment that is suspended. That's really the principle. Unless, if your lordship differs with me on that point, then I'm out. But in our law, you cannot rely on the very judgment that is being appealed. as an excuse. Because why? By operation of law, not by your lordship's decree, not by my wishes, not by the wishes of Mr. Zuma, not by the wishes of any of the accused. By operation of law, this is the law. Section 18(1) of the Superior Courts Act. Lordship will excuse me, I read this to you last week, but it was in a different context. So maybe we need to do this very slowly so that we can educate the legal position. Section 18(1) is very simple, my lord. It says, subject to subsection 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision, not an order, a decision, which is the subject of an application for leave to appeal, or of an appeal. Let me pause there. The subject of an application for leave to appeal. Now we're told now, only if the appeal succeeds will the section 18 apply. That's just not the law. Is suspended pending the decision of the application, on that application. In other words, my lord, to bring it home, the operation of the judgment of the SCA, which is now the subject of an application for leave to appeal, is suspended pending the decision of that application or appeal. Simple. There's no complication at all. So to sit here and take us chapter and verse of the judgment of the SCA, which according to the law is suspended pending the decision of the application to appeal, is just a mighty waste of the court's time. Quite apart from the fact that, my lord, that decision, and I don't want to bore your lordship because there's nothing your lordship can do, by showing you how bad this decision of the SCA is. That's why we, even in that day, we just waived the notice. We didn't go into the grounds, my lord. But please, your lordship, just indulge me for 5 minutes just to point out why this judgment will not even stand. The very first sentence of this judgment is wrong. And the very first sentence of the second paragraph is also wrong. It says, the appellant, this is after the judges, paragraph 1. The appellant, Mr. Jacob Zuma, the former president of this country, is facing multiple charges of corruption and so on. He first appeared in court in relation to those charges on 29 October. His trial has still not commenced. Then the next one. In 2021, Mr. Zuma finally had to plead to the charges. He did not plead to the substance of the charges. He raised a special plea in terms of Section 1061H of the Criminal Procedure Act 51. That is not true. I was standing here on that date. It was the 17th of May of 2021. And we pleaded, as we must, as your lordship knows. You can't just plead 1061H. You have to plead it together with 115. So we pleaded to the merits. So the court was either misinformed or wrong, and we explained all this to the court. There are many, my lord, examples like that. And then we're told, this is one where I don't have to explain, your lordship will be familiar with it from the other case. It says, private prosecutors also against the second respondent, Ms. Karyn Maughan, a senior legal journalist who has been reporting on criminal deliberation, his criminal indictment, and the numerous legal challenges and proceedings for well on 20 years. I don't have to go to that. That's wrong. The judgment of this court said that 10 of those 20 years were Mr. Zuma and the NPA responding to the DA. So that's completely wrong. And then it said that It says, a key plank of this appeal is that no other court has been ready to accept the characterization Stalingrad as was the High Court in this matter. That is not entirely accurate. In Democratic Alliance versus President, 3 judges of the Gauteng Pretoria found that Mr. Zuma has adopted Stalingrad defense strategy, which has cost the state well up to so much. That's also wrong, because our submission was never about that case. It was that the cases that are relied on, you remember that long list, my lord, the so-called chronology of delays. The cases that lie there, none of them, including Judge Kuhn, including the full court here, including even the spy tapes case, in none of those cases was it ever found that those cases were abusive or delayed. That's all we're making. So it doesn't help to go and bring another court case that is not on that list. So again, the SCA either misunderstood what we're saying or misdirected itself. I can go on, my lord, but the crux of the mistake is in paragraph 15. This is the heart of the problem. And it stems from a submission which was made by Mr. Inukaitobi in the SCA, which was accepted wrongly and which we're 100% sure will be reversed by the Constitutional Court. It says there's a judgment, a finding there that there's abuse and so on and so on. Then it says, for the present, the correctness of that key finding is not before us. The matter is before the main appeal, which is true. And then the court makes the ultimate blunder. It says that the finding stands until set aside by a court of competent jurisdiction. That is wrong in law. A finding cannot stand. Section 18.1 says the exact opposite. The decision, in other words, the order and the judgment does not stand until the appeal is the exact opposite. The law is exact opposite of what Judge Conan
Yeah, but I mean, I did
Things stand, there is a judgment of the Supreme Court of Appeal penned by opponent J.A. J.G. Zuma versus W.J. Downer and K. Maughan, reportable case number 788/2023, ZASCA 132, delivered on 13 October 2023, in which the Supreme Court of Appeal, when dealing with Mr. Downer and Ms. Maughan's constitutional right to dignity, pointedly stated in paragraph 24 at page 13 that on each occasion that the respondents, Mr. Downer and Ms. Maughan, are compelled to appear in the criminal dock, their personal liberty is further inhibited and human dignity further eroded. I'm alive to the fact that that judgment is being taken up on appeal. However, I hold the view that where a person's constitutional rights are at stake, it is better to err on the side of caution. Mildly put, I therefore do not consider it just, for the purposes of the present application, to order Mr. Downer and Ms. Maughan to sit in the dock as accused persons. Mr. Mpofu's request is therefore refused.
My Lord, I assume we then proceed with the second issue. Yes. I must maybe, my Lord, just to register my client's instructions on the issue of whether or not the judgment is suspended, the judgment of SCA. And my Lord, it is simply to say that whatever, hopefully your Lordship will make it clear that whatever, if we do ask for further reasons, whatever judgment your Lordship has, or ruling has made, which we obviously have to accept for now, does not preempt what will happen in the Constitutional Court.
Yes.
Yes. Should I accept that as a...
No. It just does not.
Yes. Thank you, my Lord. And as I said, we'll wait to see if the other side will therefore not...
Don't push me into making credibility findings, Mr. I'm avoiding that at all costs.
Yes. No, my Lord. I'm not, my Lord. Your Lordship will... let me put it this way. We will probably apply for further reasons so that we can deal with the matter. But that's for another day, another forum. Yeah. Now, my Lord, regarding I don't know where we are now, whether we're in the back in the criminal prosecution.
Yes, we now have to make a decision with regards to what is going to happen with the
current prosecution.
Private prosecution.
Private prosecution. Yes. Okay. All right. Well, if we're back in the private prosecution, then, my Lord, our submission is that in fact, we have made an overture prompted by, as I said, by your Lordship's intervention last week. What happened, my Lord, very shortly is that after the court's intervention, your Lordship again was not aware, I'm sure, that the attorneys in last week's matters were different to the attorneys now. Yes, and in fact, it's also our fault we did not point that out. So what then happened, my Lord, is that those attorneys then took over the matter. And on Friday, my Lord friend Mr. Badlander and I had a discussion, and then the consultations took place over the weekend. On Monday, my Lord, we came back to the other side, pointing out some of the things that we have pointed out now this morning, so I don't have to go through it. And the crux of that, my Lord, was that A, they should have approached us, and they failed to do so, and B, that there are no special accused persons, which we hope the wrong message must never be sent in that direction, that there are accused persons who belong to the normal rules of the courts and those who don't. my Lord. And in that respect, my Lord, I want to take your Lordship to the following sections of the Criminal Procedure Act. I want to refer your Lordship to Section 11. We've discussed that ad nauseam. And I've made reference to the Ramaphosa case. And I want to explain why this situation really is bound to send the wrong message to the public out there, which is watching these things really and must be puzzled sometimes at what happens. Section 158, my Lord, of the Criminal Procedure Act says the following. And it includes what we're doing now, which is the private prosecution. Section 158(1). Except as otherwise expressly provided by this Act or any other law, all criminal proceedings in any court shall take place in the presence of the accused. Right? And needless to say, it's in the presence of the accused, in the where the accused is supposed to be. And then there's Section 170, my Lord. Of the Criminal Procedure Act. Let's start with 170, we'll come to 168 just now. 170 says, my Lord, yes. And 171, an accused at criminal proceedings, such as this one, who is not in custody and who has not been released on bail and who fails to appear at the place and on the date, the place being the court and the dock, and on the date at the time to which such proceedings may be adjourned, or who fails to remain in attendance at such proceedings as so adjourned, shall be guilty of an offense and liable to the punishment prescribed under subsection 2. And that sentence in subsection 2 is a fine not exceeding 300 rand or imprisonment for a period not exceeding 3 months. So that's the background, which takes us to section 168, where we are now. And section 168 says, a court before which criminal proceedings are pending may from time to time during such proceedings, if the court deems it necessary or expedient, adjourn the proceedings to any date on the terms which the court may deem proper, I suppose, and which to the court may seem proper, and which are not inconsistent with any provision of this Act. Right. So that's where we are now, my Lord. The current proceedings where we're sitting now can, as it happened on the 4th, be adjourned to the next date. I don't want to address your Lordship about the similarity of the position between the 4th and now. The Lordship has already made a ruling regarding that. But the point we're making is that the normal way to deal with them is this. Now comes the question, so we're saying, my Lord, your Lordship has obviously is empowered to postpone the matter. And just to make it clear, we are not opposing the postponement. We couldn't under these circumstances, for the same reasons that we didn't oppose it previously. But Your Lordship, the only issue remaining then is when must it be postponed to? Mr. Ngoitobi has already suggested that it would be postponed if there's a postponement to sine die. And we have made a proposals to the other side, my lord, a proposal to say the matter should be postponed to the 9th of April, 2024. And we explained, I just don't have the letter now, the letter we sent to them, we said, oh, I'm sorry. Yes, I sent a letter and also a message to Mr. Kaplan. But let me explain why such a long postponement, because obviously courts don't normally give long postponement. It is to accommodate this, or to avoid all this situation for the convenience of all the parties. Firstly, to comply with the law, which says criminal matters should not normally be postponed sine die. But secondly, to make sure that we don't come up and down here, and allow for a period where we would come back, as in the Joburg matter, and in April next year, which is
2024.
No, I'm just trying to measure how many months. It's about 6. Yes. So in about that period, then, my lord, hopefully something would have happened, either with the Constitutional Court appeal or the main appeal of the
SAA, in this SAA.
Yes, and we would duly come to the court and say, one thing, this has happened or has not happened. And if it hasn't happened, we just do another long postponement. This was, by the way, my lord, what was suggesting is exactly what was done when President Zuma had his Section 17 application in the SCA. The ruling that we gave you last week in the other matter. Justice Kuhn then gave those long postponements to await the outcome of whatever was happening in the SCA, and then we would come back and do what we call a report back. If nothing had happened in the Concord or the SCA, we would then do another postponement. So that's exactly what we are suggesting, is exactly what was done when the shoe was on the other foot. So, in short, my lord, that is what we propose will happen, but I'll respond to whatever my learned friends have to say further. But that's our proposal, because we don't want a situation where the matter just kind of fizzles away.
What's your take on the removal of the matter?
Yes, I'm coming to that now. As far as the proposal, my lord, there's no legal basis for that at all. But you know, we've seen things in this case, my lord. So I'm sure if there's no legal basis, it will be found somehow by my learned friends. But there's no known legal basis upon which this court can give such an order for a removal of the matter under these circumstances, when the only basis to do so is a judgment, which by all accounts is suspended. I mean, that's just the law. Whatever my learned friends have to say about there is an application for leave to appeal regarding that judgment. And in the South Cape case, my lord, it goes further than just talking about the judgment. It says the judgment has no effect. So it cannot be given effect, the judgment of the SCA, lawfully. The only possible basis, my lord, for a so-called removal is, as your lordship knows, under Section 6 of the Act, which says an Attorney General, that would be Mr. Zuma for now, or an NDPP, or any person conducting a prosecution at the instance of the state, or anybody or person conducting a prosecution under Section 8, may, that's a private prosecutor, which is an entity, may, before an accused pleads to a charge, withdraw the charge, in which event the accused shall not be entitled to a verdict of acquittal in respect of that charge. So that's the one instance, madam. The other one is at section 342. I don't have section 342, but I think it's section 342B, 3B, or if I stand correctly, where if there's an undue delay, the court, and the person has not yet pleaded, the court may then remove the matter in the interest of justice. There's no other known legal basis upon which a matter which is extant and simply the subject of proceedings in another court is removed. Mr. Mukatewi, and I don't know if it was him, had a matter recently like that where the leader of the political party was charged for land invasions or whatever. And then they then challenged the matter in the Constitutional Court, the section. So pending that, and it was in Newcastle, that case, pending that challenge, then the matter obviously was then postponed, and they would come to court and report back in the normal way until the Constitutional Court that made that decision. That's the law. That's how it happens with everyone else in the country. But we'll hear why it must be different when it's Mr. Zuma. Yes. So the short answer, my lord, is like, unless there's a legal basis upon which your lordship can be pointed, in which I'll deal with in reply. Yes. The matter should simply be postponed, and the only question is to which date? To when. And in our respectful submission, what we've put is reasonable, madam. It must be remembered that this is not a state prosecution. This is a prosecution at the instance of Mr. Zuma, his dominus litis. Yes. This is his matter. And if he, as the prosecution, is proposing that the matter be handled in a particular way, of course, he can force people to sit wherever they, although it's his court, quote unquote, it's still it's your lordship's court. Yeah. But for the purposes of the further conduct, my lord, the preference of the person who is in charge of the prosecution should be heeded. Yes,
thank you, Mr. Yes, Mr. Breitenbach.
Yes, thank you, my lord. Key to the question with which you are currently seized, which is removal or postponement, is to be found in the opening phrase of section 168 of the Criminal Procedure Act. As your lordship knows, it contains a jurisdictional fact. That is, a court before which criminal proceedings are pending may adjourn the proceedings to any date on terms to which the court may seem proper and which aren't inconsistent with any of the provisions of the Act. So the question is, are there criminal proceedings pending before your lordship? Is this private prosecution pending before your lordship? And in that regard, I wish to take you through aspects or parts of the note which was handed up today. Our submission is that there are no criminal proceedings pending before your lordship, and if I may, I shall return at the end to what I say in paragraph 1, which is the directions which Mr. Downer seeks from your lordship. Or perhaps I should, just for the sake of clarity, explain what it is that he asks be done today. As appears from paragraph 1.1, he asks firstly that you direct that the private prosecution by Mr. Zuma of Mr. Downer and Ms. Maughan under case number CC 52 of 2022P, which I shall call the private prosecution, is removed from the roll of this honourable court, and it will stay so removed pending the outcome of any and all applications for leave to appeal and any appeals against the judgment and orders of the full bench of this honourable court, per Kruger, Henriques and Masipa JJ, dated the 7th of June 2023, in case numbers 12770/22P and 13062/22P. I shall refer to those judgment and orders as the main judgment and orders in the abuse, the applications brought by Mr. Downer and Ms. Moore. Secondly, he asks that you direct that such removal from the role is without prejudice to the rights of Mr. Zuma in terms of Section 11 of the Criminal Procedure Act 51 of 1977. I shall explain to your Lordship that that is not strictly necessary, but there's no harm in making it clear that there is no prejudice to Mr. Zuma. And thirdly, Mr. Downer asks that you direct that if the order of the full bench made in the main case on the 7th of June 2023, which amongst other things set aside the summons in the private prosecution, if that order itself is finally set aside by a court on appeal, then Mr. Downer and Ms. Moore will again appear as accused persons in the private prosecution on a date to be determined. So in substance, it is a request for removal from the role. We wait for the outcome of the appellate processes in which Mr. Zuma is currently engaged in relation to the June main judgment, and if he prevails in those proceedings, then the matter will be re-enrolled and they will again appear on a date to be determined, obviously by your Lordship, on being informed of the outcome. I set out in paragraphs 3 to 10 or 11 the 8 salient facts, and it's perhaps as well that I briefly recount them. The first is that on the 5th of September 2022, Mr. Zuma instituted the private prosecution against Mr. Downer and Ms. Maughan, and he did so by causing a summons to be issued out of this Honourable Court. Secondly, on the 7th of June 2023, the full bench of this Honourable Court, which I've just mentioned, delivered their main judgment in case numbers 12770 of 22P and 13062 of 22P. In that judgment, as your Lordship knows, the full court found, amongst other things, that the private prosecution was an abuse of the process of this Honourable Court, and it consequently ordered in paragraphs A1 and B1 that Mr. Zuma's summons is set aside. The third material fact occurred on the 3rd of August 2023. That was when the full bench granted applications by Mr. Downer and Ms. Maughan in terms of sections 18 sub 1 and 18.3 of the Superior Courts Act. The relief that they sought, and which was granted, was in essence that the main judgment and orders of 7 June 2023, save for those in relation to costs, be carried into effect, notwithstanding and pending any applications by Mr. Zuma for leave to appeal or any appeals against the main judgment and orders. The third full bench consequently ordered that the operation and execution of, amongst others, its orders in paragraphs A1 and B1, those are the ones setting the summons aside, shall, to use its word, remain in force and not be suspended pending the final determinations of any applications for leave to appeal or any appeals against the main judgment. The full bench further ordered, specifically in relation to Mr. Downer, that the private prosecution of Mr. Downer is suspended while Mr. Zuma is pursuing his appellate options in relation to its main judgment and orders. And I pause to say that if that order stands, then the jurisdictional fact for the exercise of a postponement power in section 168 of the CPA is absent. The reason being that there is no criminal proceedings pending before this court today. The fourth material fact occurred on the 14th of August 2023. That is when Mr. Zuma exercised his automatic right of appeal to, I quote, the next highest court, unquote, being the Supreme Court of Appeal in section 18 sub 4 of the Superior Courts Act. And that appeal was directed not against the main judgment and orders of the full bench of 7 June, but against the 3 August 2023 judgment and orders of the same court in terms of sections 18(1) and 3 of the Superior Courts Act. In other words, it was directed against the decision on the 3rd of August by the full court to bring into effect parts of its main judgment and orders pending Mr. Zuma's appeal against them. Now, as the court will know, pursuant to section 18(4) Roman 4 of the Superior Courts Act, by Mr. Zuma's exercise of this automatic right of appeal, the effect was to suspend, pending the SCA's decision on the appeal, those are the words used, pending the decision of the next highest court, the implementation of the orders which the full bench had made on 3 August 2023. And so, as a result of the exercise of that automatic right of appeal, Mr. Zuma caused to be suspended the full bench's main judgment and orders of 7 June 2023 in toto, but that was done pending the SCA's decision. The fifth material fact occurred on the 11th of September. On that date, the full bench dismissed an application by Mr. Zuma for leave to the appeal to the Supreme Court of Appeal against its judgment and orders of 7 June 2023 in the main case. Seventhly, a month later, on the 11th of October 2023, Mr. Zuma brought the same application, this time in the SCA. So he applied to the SCA for leave to appeal against the full bench's main judgment and orders of 7 June 2023. And that application is currently pending before the SCA. The seventh fact, perhaps I should interpose to say that something else happened which is material, and that is, as my learned friend indicated earlier, on the 4th of August this year, Your Lordship made an order in the private prosecution postponing the matter to today and setting the matter and requiring that the accused, then accused, attend. But what has happened in the meantime, crucially, is that on the 13th of August 2023, in the judgment of the SCA to which Your Lordship referred in his ruling, that court dismissed Mr. Zuma's appeal in terms of section 18(4) of the Superior Courts Act. And as I shall explain more fully in a moment, the dismissal of that appeal had the effect of bringing into effect the implementation orders of the full bench which were made on the 3rd of August. Chief among those then is the order setting aside the summons in the private prosecution pending the final outcome of Mr. Zuma's attempts to appeal against the main judgment. So that was where matters stood on the 13th of October. And were it not for the last event, I do not believe that there would be any contestation before Your Lordship that the jurisdictional fact in section 168 is not met, for the simple reason that the full court has ordered that Mr. Zuma's summons be set aside for now, pending the outcome of his appeal process. And that order has been put into effect pending the outcome of his appeal processes. So, my Lord, everything turns on the application, the 8th fact, the application for leave to appeal against the SCA's judgment of the 13th of October, not against the full court's judgment of the 3rd of August, but against the SCA's dismissal of Mr. Zuma's appeal against the full court's judgment of the 3rd of August. That application was made to the Constitutional Court, and what it seeks to do is to assail before the Constitutional Court one thing and one thing only: the SCA's dismissal of his appeal in terms of Section 18.4 of the Superior Courts Act. Now that application, as my learned friend has indicated too, is currently pending. We respectfully submit that despite that application for leave to appeal, the dismissal by the SCA of Mr. Zuma's appeal in terms of Section 18.4 of the Superior Courts Act is final. And in that regard, we wish to draw your Lordship's attention to a judgment which I know was appended to correspondence to your Lordship, and I understand was also referred to in court last week in last week's matter. It is the City of Tshwane Metropolitan Municipality and Vrestina case to which my learned friend Mr. Nuka Etodi referred and my learned friend Mr. Mpofu referred. And with your Lordship's leave, I'd like to read paragraph 16 to the court, because it relates to 2 points that I intend to make in relation to that one. It provides Section 18.4 Roman 2 introduces a provision that grants an automatic right to appeal to the next highest court against an order under Section 18.3 of the Act. The provision is unique because it changes the general appeal process in that such orders, that's obviously a reference to an order issued under 18.3, being interlocutory in nature, are generally not appealable, and that leave to appeal must first be obtained before an appeal can be lodged. Section 18.4 establishes a mechanism for a single appeal that will be concluded in an expedited process, as evidenced by the absence of provisions for appealing the decision of the next highest court. In essence, the decision made by the next highest court in the appeal process is final and cannot be appealed any further. Yet we know that there is an application for leave to appeal by Mr. Zuma against such a decision. Now, in our respectful submission, it means...
So in other words, you are saying there is only one appeal.
So says Section 18 of the Superior Courts Act as interpreted by the Supreme Court of Appeal. In this instance, it means that the SCA's judgment and order of the 13th of October 2023, dismissing Mr. Zuma's appeal in terms of Section 18.4 of the Act against the implementation judgment of the full court of the 3rd of August is final, and it cannot be appealed any further. And it further therefore means that Mr. Zuma's 25 October 2023 application to the CC for leave to appeal against the SCA's judgment and order of the 13th of October is a nullity. It is something which the SCA has said cannot legally be done. There is, to quote the SCA, no appeal against the decision of the next highest court because it is final and cannot be appealed any further.
And you say the next highest court in this regard is the SCA?
Yes, there was a full bench. It's gone to the SCA, one strike. Whichever way it went, it's final. So in our most respectful submission, this is our primary submission, unless and until the SCA's interpretation of Section 18.4 in City of Tshwane is overruled by the Constitutional Court, it is binding on all courts in South Africa, including with respect this Honourable Court. And it was interesting to hear my learned friend, Mr. Mpofu, today from Mr. Zuma saying that he personally has reservations about the constitutionality of aspects of Section 18 and specifically this expedited appeal. But he did confirm that he's approaching the case today on the basis that Section 18 is what it is, it says what it says. In other words, he bases his argument on Section 18. And indeed, he attempted to persuade your lordship that section 18.1 applies because of Mr. Zuma's further appeal. Now there are two problems with that proposition, with respect. I've dealt with the first. Section 18 doesn't allow further appeal. It's the end of the road to 18.4. I wish to turn to the second problem, and the submissions which I shall now make are in the alternative to the submissions which I've just made, to the effect that there can be no further appeal. So, if contrary to what we have submitted, perhaps before I do that, I should just make a brief submission about the Tasima case. You'll recall this morning you were referred to Tasima. That's the judgment of the Constitutional Court, which is reported at 2018, volume 9, of the Butterworth's Constitutional Law Reports, 1067 Constitutional Court. With respect, paragraphs 52 to 54 of that judgment, to which you were referred, have nothing to do with whether, following the determination of an appeal in terms of section 18.4, the losing party may appeal further against the decision of the appellate court, the next highest court. Tasima deals with a different question entirely. The issue up for decision there concerned the duration of an enforcement order, an interim enforcement order made under section 18.3. Tasima holds that the order, of which the full court's order is of the 3rd of August is an example, it will endure until the finalization of the appellate process against the main judgment, and that when that process is over, whichever way it goes, then of course the interim regulation of the procedure or the relations between the parties falls away. That's what Tasima is dealing with, and one must obviously keep entirely separate the appellate process, which in this case has moved to the SCA in relation to the main judgment, and then this entirely separate question about whether there's a second strike, a second appeal in an 18.4 scenario. So with respect, Tasima is not relevant. What then if your lordship is against us on our primary proposition that paragraph 16 of the City of Tshwane case means what it says and is binding on you? So assuming you're against us on that. Then we have Mr. Zuma has an application for leave to the SEC, which isn't a nullity, an application for leave against the SCA's 13 October judgment. Then in those circumstances, we respectfully submit that section 18.1 of the Superior Courts Act does not come into play. The reason is that we are dealing here with a section 18.2 order. The 18.2 is the one which, as the court will know, relates to, I'm quoting it, a decision that is an interlocutory order not having the effect of a final judgment. And your lordship will already know where I'm going with this, because in paragraph 16 of City of Tshwane, that is how the court characterized an order of this kind, before going on to say, and section 18 creates an exception to the rule relating to appealability and introduces this interim suspension while you're exercising that right. So our essential propositions on leg 2, if I can call it that in the alternative, are firstly that the SCA's judgment and order of the 13th of October 2023 will be appealable only if the Constitutional Court grants Mr. Zuma's application for leave to appeal to it. And secondly, and crucially for the issue that you have to determine today, namely whether there is a pending criminal matter before you, pursuant to section 18.2 of the Superior Courts Act, Mr. Zuma's application for leave to appeal to the Constitutional Court does not suspend the operation of the orders setting aside his summons in the private prosecution, which were made on the 7th of June and which were confirmed by the SCA. Now we accept, of course, that Section 167, 6B of the Constitution provides that national legislation or the rules of the Constitutional Court must allow a person, when it's in the interests of justice and with the leave of the Constitutional Court, that's the wording of the provision, to appeal directly to the Constitutional Court from any other court. We accept also that Rule 19 of the Rules of the Constitution regulates the procedure to be followed in an application for leave to appeal to the Constitutional Court. And we note that Rule 19, 6A confirms that the CC is the court that will decide whether or not to grant leave to appeal. As to Section 18.2 of the Superior Courts Act, in its presently relevant part, it provides that unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal or of an appeal, is not suspended pending the decision of the application for leave to appeal. And as I've already indicated in our respectful submission, the orders made by the full bench on the 3rd of August, those are the orders setting aside Mr. Zuma's summons, or saying in effect that the earlier order in the main case setting aside his summons shall remain in force and not be suspended pending the final determination of the appellate process in the main case. Those we submit are interlocutory orders not having the effect of a final judgment as envisaged in Section 18.2 of the Superior Courts Act. And we rely on 2 SCA cases for that proposition. The first is Ntlemeza, a case referred to in the city of Tshwane. Ntlemeza, N-T-L-E-M-E-Z-A versus Helen Suzman Foundation and another, 2017, Volume 5, SA 402 SCA, paragraph 20. And I quote, and this is in describing the common law position. In South Cape Corporation Pty Limited versus Engineering Management Services Pty Limited, 1977-3 SA 534 Appellate Division, this court went on to hold that an order granting leave to execute pending an appeal was one that had to be classified as being purely interlocutory. And again in paragraph 25 of that judgment, in terms of Section 18.2, this is a heading, in terms of Section 18.2, an interlocutory order that does not have the effect of a final judgment. Then follows a colon, and the court says, the default position, a diametrically opposite one to that contemplated in Section 18.1, is that the principal order is not suspended pending the decision of the application for leave to appeal or appeal. And in City of Tshwane, at paragraph 16, as I've read to your Lordship, the court held that Section 18.4.2 introduces a provision that grants an automatic right to appeal to the next highest court against an order issued under Section 18.3 of the Act. It's a unique provision because it changes the general appeal process in that such orders, being interlocutory in nature, are generally not appealable, and that leave to appeal must first be obtained before an appeal can be lodged. So we respectfully submit that the Supreme Court of Appeal's characterization of an order issued in terms of Section 18.3 as an interlocutory one, not having the effect of a final judgment, is a dictum which is binding on all courts in this country, including with respect to this Honourable Court. And as such, the orders made by the full bench in terms of Sections 18.1 and 3 on the 3rd of August and confirmed by the Supreme Court of Appeal on the 13th of October are governed by Section 18.2 and not by Section 18.1 as submitted by my learned friend. And as just explained, that means they are not suspended pending the decision of the Constitutional Court on Mr. Zuma's application for leave to appeal against the SCA's judgment and orders of 13 October 2023. So either the appeal is a nullity or The appeal is against an interlocutory order which is governed by section 18.2, because the one thing the other side does accept is that there is only one section 18 for appeal. This further appeal will be against an interlocutory order, being the 3 August orders of the full court. It is not suspended. And because those orders provide that the summons is set aside for now, or differently put, in Mr. Downer's case specifically, the criminal proceedings are suspended. Hence the argument with which we started today and we persist now in relation to what to do now, that there is no pending matter before your lordship, and consequently you may not exercise the power of postponement conferred on you by section 168 sub 3, because the presence of that jurisdictional fact is a prerequisite for any exercise of that power. I repeat, a court before which criminal proceedings are pending, comma, may. One sees that formulation throughout our legislation, and that's a question which your lordship has to determine. As my learned friend Mr. Toby put it, is there a valid criminal private prosecution? I perhaps prefer to say, is there an operational private prosecution in the light of what the full court and the SCA have decided? So what then is the presently relevant effect of the orders of the full court on the 3rd of August, as confirmed by the SCA on the 30th of October? The first is that the orders setting aside the summons for now are not suspended. They are in force, and they remain in force, to use the words of the full court pending these appeals. And so it follows that unless and until Mr. Zuma is granted leave to appeal and succeeds with his intended appeal against the full bench's main judgment and orders of the 7th of July, the summons is and shall remain set aside. And right now, that's the position, legally speaking. And I most respectfully say it further follows that because of that order, which was made by this division, full court of this division, this matter should not be on today's rod. It's like the appeal in the city of Tshwane matter. The court was there seized with a purported second appeal. And the court held that it had no jurisdiction to entertain a purported second appeal. And it consequently ordered that the appeal be removed from the roll because it shouldn't have been there in the first place. Obviously it did so after hearing the parties on the question whether the appeal should have been there in the first place, as your lordship with respect is correctly doing now. But the simple fact of the matter is that between the date in which your lordship adjourned this matter today and today, a very significant supervening event has occurred, and that is that the SCA has spoken in the one and only appeal against the full court's order, affirming it with the result that from 13 October onwards, that order has been in place. In other words, the matter ought to have been removed. But here we are. And, my lord, what to do about that practical reality here? One must follow the example of the SCA in the Vestina case and remove the matter from the roll. It shouldn't be here. If that is your lordship's conclusion, if you're with us on either of the two bases, that is the appropriate order. It is entirely within your rights, and indeed with the greatest respect, it's your duty in the exercise of your inherent power to regulate the process of this court in the circumstances in which we find ourselves, two higher courts having spoken and determined that we ought not to be here. And I'm not going to go to the passages about the injury to Mr. Dana and Ms. Maughan on account of having had to appeal against today. It must be removed from the court. I said in opening that Mr. Zuma is concerned that he will lose, that he will somehow be snookered by Section 11 of the Criminal Procedure Act.
Well, he's not concerned about that. It will be taken care of.
It must be so,
No.
because for two reasons really. Firstly, if the matter is removed from the roll, Section 11 can never operate against him. It provides in its relevant part that if the private prosecutor doesn't appear on the date set down for the trial of the accused, the charge against the accused shall be dismissed unless the court finds that he had a good reason for not being there. The point is, having removed the matter from the roll, the case will not be set down for the trial of the accused on any date. It will only happen if Mr. Zuma ultimately prevails in his intended appeals against the 7 June orders. So there is no need for anything to be said in connection with Section 11. But Mr. Downer, as your Lordship will have seen from correspondence and have heard from me today, he doesn't want to be seen to be taking advantage of Mr. Zuma in any way. So, in the light of his apparent anxiety that somehow Section 11 will operate against him, Mr. Downer has absolutely no objection to your Lordship directing that the removal of the private prosecution from the withdrawal is without prejudice to his rights under Section 11(1) of the Act. Finally, my Lord, in the event that you're against me on everything that I've said and you conclude that there is indeed a criminal prosecution pending before your Lordship, then your Lordship obviously is obliged, because the matter hasn't been set down for trial and no one wishes it to proceed to trial today, to exercise the power conferred on you by Section 168, which, as I remind you, requires that they be adjourned to a date and on terms in which to use him proper. In the light of your ruling earlier today and what we've heard from the other side today, in the event that you're against me, I'm instructed to propose the following: that the matter be postponed to the 9th of April 2024, and that would be as a holding date. Secondly, as to the terms of the postponement,
Just a moment.
as to the terms of the postponement, that 1 week before that date, Mr. Zuma report to the court and the parties in writing on the status of the appellate process. And
Just a moment.
thirdly,
Sorry. Mr. Zuma to report to.
the judge and the parties in writing on the status of the appellate process.
Yes.
And in the light of the considerations which actuated your Lordship's ruling earlier today on Mr. Zuma and Ms. Maughan not having to, Mr. Downer and Ms. Maughan not having to occupy the dock, we most respectfully submit that it would be appropriate if you were to direct that Mr. Downer and Ms. Maughan need not appear in person on the holding date, and instead that they be represented by their legal representatives who shall appear. And similarly, there would be no need for the private prosecutor to be here on that date, that he too can be represented by his legal representatives, because what's likely to ensue, hopefully, a far briefer discussion than today on the date and terms of the next postponement. So, my Lord, what we're essentially saying is that on that date, neither the private prosecutor nor the accused need to appear in person. They shall, however, be represented by their legal representatives. Those are our submissions.
Mr. Muraitubi, please come to my rescue. Will you be brief, please?
Yes, I intend being very, very brief. There are really two submissions I want to make to your Lordship. Submission number one is to add 1 point to what Mr. Breitenbach has said about the continued prosecution of Ms. Maughan. The second is to support the alternative submission, which is, regardless of where we land, the question remains, if you postpone the matter to April, the date Mr. Mpofu proposes, should Ms. Maughan be in court or not? Let me deal then with the first issue. The question then is, on the first issue, has to be decided by asking whether the order of the 7th of June 2023 remains operational or has been suspended. If you hold that that order remains operational, then of course you must remove the matter from the roll or strike it from the roll. But if you order that it remains operational, if you order that it is suspended, then you have a discretion whether or not Ms. Maughan should appear on that date. On the first issue, which is whether or not the order of the 7th of June is operational, we say that that order is operational. The SCA judgment has been referred to by Mr. Pietermaritzburg. Interestingly, in the debate we had earlier, Mr. Mpofu said he agrees with the SCA judgment in Tswana. In other words, it's a correct judgment. So the real issue then is whether their appeal to the Constitutional Court has the order of suspending the operation of that order. Not whether they have a right to approach the Constitutional Court. Everybody accepts that they do. Section 167 of the Constitution is clear. But the question is whether their application for leave to appeal has any effect on the continued operation of the order of the 7th of June. The answer to that is against them on two fronts. First, on the text of Section 18 itself. My learned friend, Mr. Mpofu, relies on Section 18.1 that says, subject to subsections 2 and 3, and unless the court, under exceptional circumstances, orders otherwise, the operation and execution of a decision, which is the subject of an application for leave to appeal, or of an appeal, is suspended pending the decision of the application or the appeal. So if you look at where the section starts, it's subject to subsections 2 and 3. What those sections are about are precisely what has been happening here, which is there was an application, and that application was decided against Mr. Zuma. And what happens is where that order has been granted, in other words, where the execution has been granted, Section 18, subsection 4 applies. And that section has 4 subsections. 1, the court must record its reasons. 2, the aggrieved party has the automatic right of appeal to the next highest court, and that has been exercised now. And then the court hearing the appeal must do so as a matter of extreme urgency. And then such order will be automatically suspended pending the outcome of such appeal. And the such appeal is the appeal to the next highest court. So that right of the automatic suspension has come and gone. Once the SCA made a pronouncement, that was the end of the road. That is, in fact, the finding in the City of Tshwane case. And if that finding is correct, the the Superior Courts Act is clear on the subject. It has nothing to do with, are you entitled to go to the Constitutional Court and complain about that ruling? The question is, while you go to the Constitutional Court, is the decision suspended or does it come into operation? That's answered by the statute. It comes into operation after you have reached the next highest court. They've reached the next highest court, the decision now comes into operation. They no longer have a right to the automatic suspension in sub 4. And they don't have a right to the general suspension in sub 1 because it is subject to 2 and 3. So on the text of Section 18, you don't have to decide whether they have a right of a further appeal. You simply have to decide whether they exercising their rights of appeal has any effect on the operation of the order. And it has no effect on the operation of the order. So what that means is that in the text of under the text of Section 18.1 and 4, the decision of the 7th of June is operational, which means that there is no proper basis for a convening of the court under the guise of a private prosecution. So that's one point to be added to the otherwise erudite exposition of the City of Tshwane case. Then the next point is, well, if your lordship is nevertheless not minded to entertain this complicated discussion, and your lordship simply takes the view that what I'm here as a criminal court judge, I have to decide what happens to the criminal prosecution, I'll wait for the constitutional court. The question does not automatically follow that therefore the accused should be present. Your lordship still has a discretion to excuse the accused if it is in the interest of justice to do so. And that's the second submission I want to make here. And we already made this submission. So in other words, it is not a binary issue that there is either a valid prosecution, and if there is no valid prosecution, the accused must come. Even if your lordship took the view that there is a prosecution, or at least there is an argument about the prosecution, the question remains, should the accused be here or not? Now, the answer to this question, if it is discretionary, is already outlined in the SCA judgment at paragraphs 23, 24, and 25. And we debated those, I don't want to repeat them. And in summary, there is the authority of the court's point, which I have already made. Number two, there is the human rights argument, which your lordship kindly pointed out to me. And then number three, there is the underlying abuse by Mr. Zuma of the private prosecution regime. Those are the 3 points made in those paragraphs. Now, it is true that Mr. Mpofu has criticized the Supreme Court of Appeal judgment. And he says that they have made numerous mistakes and that the Constitutional Court will take one look at it and overturn it. That may be his dismissive attitude to the judgment, but it does not have to be your lordship's attitude to the judgment, because your lordship will follow the stare decisis and will not be tempted to engage in the criticism of the superior courts as invited. So, there are those considerations that are in paragraph 23, 24, and 25. And you can ignore the attempt at undermining the authority of the Constitution, of the Supreme Court of Appeal. And then you also hear that you should follow the President Ramaphosa instance, which is they are still going to court, and the matter is being postponed every time they go to court. The problem is twofold. On the 3rd of October, we made precisely that proposal in correspondence, where we said we asked that the matter should be removed from the roll. And alternatively, Ms. Maughan should be excused from appearing, which is precisely the order that they said they proposed we should have made. In their response, what they said is that you should do it in a formal application, which simply means that this is a fight about form over substance. Because the substance is they accept what is going on in the case of President Ramaphosa, which is he is, in effect, permanently excused until all of the appeals are exhausted. And in Ms. Maughan's case, they refuse, saying they want an affidavit. We are in court today, and we are making a substantive application before your lordship, which is Ms. Maughan should be excused until all of these appeals that they are exploring are exhausted. There is, in fact, no defense to that argument at all. There is no defense to the argument at all. So which then comes back to why then is she still the subject of this discussion? It can only be on the same basis that the full bench concluded there was a vendetta against her. Your lordship should not be part of that. Mr. Zuma can be part of it if he wants to. And which is why we say the correct order is to say what Mr. Breitenbach submitted, which is the matter is removed from the roll. But if your lordship is uncertain as to the legal correctness of this debate around Section 18, your lordship can still deal with the matter purely discretionary by simply ordering that where you have constitutional rights at stake, it is preferable to err on the side of the protection of those constitutional rights. And because the SCA has already authoritatively held that the continued appearance in the dock is a violation of those constitutional rights, they are therefore excused from further appearance. So we ask only for those 2 orders, 1 in the alternative. Thank you.
Yes, thank you. Simple.
A lot has been said, but I'm just going to try and cut to the chase. There's so much wrong happening here, as is always the case when it comes to this particular matter. Last week, you'll remember that Mr. Masuku was criticized for saying that the NPA had acted in a criminal manner. And we explained, my lord, what we meant by that. Now, it looks like there's an attempt now to make even this court a crime scene, like the NPA. Firstly, my lord, it's just that we don't, firstly, there's no application before you. We have said in the correspondence to this court and to the JP, if they want to make any application for postponement or whatever, they must do a substantive application. Once again, they defied that. You know, my lord, this whole private prosecution arose how? It arose because when Mr. Zuma was in hospital, and it was clear that the matter had to be postponed, the state said to us, you have to do an informal application. We did that application, then they leaked it to the media. That's how we got here. But now, when it's the other way around, and we say they must make a formal application in the same way. No, they can just rock up here and make an application for 2 hours where there are no papers. We have not been given any papers. We sit here and 5 minutes before the matter starts, we are given heads of argument. For what application? But I suppose, as I said, we've seen worse. So now we're ambushed here. We have to deal with an application and heads of argument that we have been begging for to be done so that we could answer in the normal way, in the way that the law that applies to Mr. Zuma. But now we're told all sorts of submissions which are self-contradictory. You are told that you must ignore the criticism of the SCA judgment, but you must not ignore the praise by them of that judgment and the reliance. You know, I mean, honestly, they rely on the very judgment. You must ignore it when it's criticized, but when it's being praised by them, you must apply it. In fact, your Lordship has already applied it in the earlier ruling, at their exhortation. That's what we're faced with in this country. Then, my lord, you're told that so people come without any application, bring ahead, there must be selective praise of a particular judgment and reliance on it. This matter is very simple, my lord. The mere reliance on the SCA judgment, if we are correct on the section 18, even including section 25 that your lordship used to say they must not go to the top, that all of that is suspended on the proper interpretation of the law. So I don't want to even go into paragraph by paragraph. We did that in the morning. But the law is that that judgment, however great it is suspended until the application for leave to appeal has been determined. Mr. Breitenbach said that pending the application for leave to appeal, this and that should happen. Those words pending the outcome of the application for leave to appeal come directly from section 18(1). And the obfuscation must be resisted. You can't say the original order of the full court, which was suspended by 18(1), and then, let's say, unsuspended by the 18(3) judgment. It is that abuse finding and all these things about constitutional rights that has been suspended. And therefore, this is a fresh application of section 18(1). So let's look at it like this, my lord. Let's assume we decided not to appeal to the SCA, the full court judgment, and then just decided directly to go to the court as we're entitled to do. What would have happened? Section 18(1) would apply, because pending that appeal, the judgment would be suspended. So it doesn't matter where you are appealing to. The court, Section 18(1) doesn't say pending an application for leave to appeal to the next highest court, it's suspended. It says pending any old application for leave to appeal, for obvious reasons, to protect the loser from what is not being protected on today and by the SCA, so that their right of appeal doesn't become academic. Mr. Mukatobi said there's no defense on his second leg to the fact about the presence or absence of the accused. I don't know what that means when we just read to the court Section 158(1), which says, except as otherwise expressly provided by this act or any other law. And I've invited them to show us where it is provided by this act, which is the CPA, or any other law for that matter. All criminal proceedings in any court shall take place in the presence of the accused. Full stop. Shall. There's no discretion. I don't know where this discretion is talking about comes from. And what then happens, my lord, is that in a normal case, there might be an application as happened, for example, in this case, with the second accused. They made an application because that accused is in France, that they should be excused. And I think there was even an agreement. But otherwise, the law is very clear on what every other South African citizen who's accused should do. I think we are making history today, as usual. It's the first time, I'm sure, in the history of this country, for the past 2,000 years, that accused persons are told that they must not sit in the dock, even when the prosecutor says that they should. But maybe we'll make more history by saying that they must also not, they must defy Section 158(1). So that's fine. We are fine with that. I mean, I think we have a keen understanding that Mr. Zuma is not like other people or other accused. And then Mr. Mukatobi says, no, I'm sorry, I think it's Mr. Pietermaritzburg. Despite the application for leave to appeal, dismissal of the SCA judgment is final. Now that can be so, man. I've explained earlier how Section 18 applies. And let me just quickly deal with the so-called Section 18(2) argument. There's no application of Section 18(2). It's just another abuse. Section 18(2) says, subject to subsection, unless the court under exceptional circumstances orders the operation and execution of a decision that is an interlocutory order not having the final effect of a final judgment, which is the subject of an application for leave to appeal, is not suspended. And Mr. Breitenbach leaves out the words interlocutory order not having the effect of a final judgment. What is the essence of that, Malo? The essence of that is, you'll find it in Erasmus A2-36 to 36A. Firstly, it explains what is meant by a decision. And then it says, the courts usually draw a distinction between a judgment and order and a ruling. The words judgment or order, as it's used in Section 20, in special technical and rather restrictive meaning, that is the old Act. The word judgment, for example, is frequently used to refer to the decision of a court as well as the reasons therefore, which I said earlier. But it is used in Section 20 is in the sense of pronouncement of the disposition. There is no essential difference between a judgment and an order. A judgment is said to be a decision of a court of law upon relief claimed in an action, while an order refers to a decision given upon relief claimed in an application, a notice of motion, and so on. Not every decision made by the court in the course of judicial proceeding constitutes a judgment or order in this sense. Some merely amount to what is termed a ruling. That distinction is not important here. And so on. So, my lord, the thing is very simple. The Zweni appealability, section 18.2, it really negates the Zweni test. Because you remember, my lord, one of the three issues in Zweni is the finality of the judgment. But now section 18.2 deals with that situation. So section 18.2 doesn't apply here. The original judgment, which was the full court judgment, is suspended because that judgment has full and final effect. That has to be common course. And the last thing, my lord, is that Nklameza. The Nklameza thing does not apply here because the Tshwane case, as I've explained earlier, again I won't go into that, deals with section 18.4. The application for leave to appeal that we have lodged in the Concord is not a section 18.4 appeal to the next highest court or whatever. That case has actually absolutely nothing to do with what we are dealing with here. Let me say this, because I think it has to be said. Despite the still in an appeal. And if they were made opita, then they are not binding on you. And if they are not binding on you, then you cannot apply them now. So either way, whether you look at it crassly for what it is, the truth, that the SCA went ahead and preempted the appeal, or whether I look at it generously and say, no, they were just making remarks in passing. Either way, that cannot be binding upon you. The question I asked, my Lord, to close it, it goes back to Mr. Downer, Mr. Breitenbach, says that the so-called jurisdictional fact is that there must be a case in front of you. That question, Your Lordship, it's not fair to Your Lordship to say that the earlier ruling about whether they must sit or not suggests that there's no case today. Your Lordship never did that in defense of Your Lordship. And therefore that jurisdictional fact remains as was ordered, that we're here for the criminal matter. And therefore the jurisdictional fact that is required in section 168 for a postponement has been met. And that's all that needs to happen, my Lord. Fortunately, despite all this hullabaloo, fortunately we all agree on one thing, that the 9th of April should be the next date if section 168 applies. And therefore, and we reject with the contempt it deserves the other orders that 1 week before that we must report to the parties. There are parties in the other court, why must we report to them what's happening? And to the court, of course, we will report when we're here. And of course, that they need to not appear in person.
Including Mr. Zuma, of course.
Yes, yeah, the same thing applies. The law must just apply as it does here in section 158. And by the way, my Lord, if we were ever inclined to ask for the court to excuse Mr. Zuma, that's a separate matter. He's the prosecutor. You know, this thing of equating Mr. Zuma to an accused must stop. Because there's this assumption that he's just here as an accused. He's here as a prosecutor, my Lord. And you know, my Lord, that in terms of Section 7, he may be represented by counsel. So whether he's here or not, quite frankly, is neither here nor there for the purposes of the prosecution. When we say the Attorney General or the state versus, we don't expect the Attorney General to come here themselves or the NDPP. The issue is about the accused persons, the people against whom there is a criminal charge. So it's not a gift to tell us that Mr. Zuma may not be here. He may not be here by operation of law. So, but the accused persons are forced to be here by the Criminal Procedure Act, not by us, by the legislation. And my Lord, the last issue, I just want to say that even the SCA that is now being praised has, in mitigation of what I've said of the SCA going overboard, at section 8, at paragraph 18, my Lord, it says, if Mr. Zuma's private prosecution is indeed an abuse of the process of the High Court, then it follows that allowing it to be enforced pending an appeal will prolong and perpetuate that approach. If. It never said what is being said here now, that it's a fact that if they stand in the dock, they're going to be abused. Or that it had to say that, my Lord, because where is that question going to be answered? In the main appeal. So we can't now operate as if that if means that it is actually a fact. In short, my Lord, A, there is a prosecution before you. B, the accused are ordered by Section 158 to be here. C, the parties are in agreement, at least on one thing, that if such a postponement happens, it should be to the 9th of February for the purposes of reporting back to the court. And we cannot oppose another application for removal or whatever, which is not before this court. It's just not there.
Right.
And we therefore would like to ask the court to grant an order in those terms, my lord.
Yes.
And in the usual way that all criminal prosecutions in South Africa are postponed, that so and so must be here at such and such a time, failing which one referrals the arrangement.
Right, I'm inclined to granting an order adjourning the matter to a specific date, and with regards to the remainder of the relief sought, I'm asking counsel to approach me in James.
My lord, I'm sorry I have to do this, my lord,
yes.
Because I just have to rush. The date, my lord, I think is already agreed between us, unless if my learned friends.
Can you prepare a draft order then along those lines?
April. Can I just confirm?
Yes.
I'm sorry, my lord.
Are you not prepared to agree on anything?
No, we have agreed on the date. That's the point I'm making. My lord, we propose the following order by agreement.
Well, the first request is adjourning the matter to the
that's done.
To a specific date. The second one, Mr. Downer and Ms. Mon to report. Mr. Zuma is to report. Just a moment, let me just have a look at this. So we need to report to the court a week before. Is that what was suggested?
That's what was suggested.
Well, I'm not going to grant that order.
That's what this is.
Sorry, the date account is April, what date?
9, my lord.
Right, the matter is adjourned to 9 April 2024 as a holding date, that is paragraph number 1. Paragraph number 2, it is directed that the parties will be represented by their respective legal representatives on the day in question.
As the worship pleases.
questions?
Answer.